Hi everybody, welcome to the webinar. This webinar is about the Court of Protection and Deputyship. So if you remember last week we had a webinar on power of attorney, and that was for people who were able to choose an appointee, so they had the ability to decide on that. Whereas today's webinar is the process of deputyship appointed by the Court of Protection, and that's where people perhaps can't make that decision and are not seen to have capacity. So this webinar is part of the new Be Human Let's Talk About series. We're hosting various themes and subjects that are important to people. Myself, Julie Stansfield and Gaynor are going to be around to facilitate and host it. If you've got any problems, pop it in the question box and we'll try and help in any way we can with any sound issues. The webinar will be recorded for others to be able to see publicly, so please be aware of that. Once it's recorded, it'll be put onto the website, the Be Human website, and it'll also go on a YouTube channel, which is the In Control Partnerships channel. How to participate today, if you've not used the webinars before, is you'll see a panel like this in front of you. After the speakers have done their presentation, if you want to come on live and ask a question, you can put your hand up here and I'll be able to come and unmute you so that you can ask your question live online. If you're not happy to do that, there's a question box here, so you can just pop your question in there and we'll take those questions and ask them on your behalf. And if you're using an iPad, it's the same. There's the hand up and ask a question. So what to expect today? I'm very pleased to welcome 4 speakers. Matthew is a partner at Irwin Mitchell Solicitors, and he's one of the leading public law solicitors, and he specialises in this area of court of protection alongside human rights, care and health and social care. Jo is applying for both types of deputyship, so she's right in the thick of it at the moment, in the middle of this process. So she's going to give us her experience about the process so far and why she decided to do that. Alan has court of protection for his daughter Anna, and he organised it all himself, so he'll talk about why and how he did this. And then we've got Jane. Welcome back, Jane. Jane was with us last week for the Power of Attorney webinar. And Jane runs supporting families to know their rights and gain information. So Jane's going to talk about the difference that having a deputyship can make when your loved ones need support in making a decision. So I'm going to first of all introduce Matthew. As I said, please save your questions till afterwards, pop them in the question box for us and we'll make sure that we can pick them up afterwards. Thank you, Matthew. Hi. So Matthew, you'll just have to switch your mute button off. There we go. Welcome.
The usual thing. Thank you very much. So as we've been hearing, last week's topic was powers of attorney, but this week we're talking about deputyship. As those who attended the previous session will be aware, power of attorney is something that someone with capacity can enter into and make a decision as to who they would like to make decisions on their behalf in the event that they lose capacity later down the line. But there'll be many situations where a person has lost capacity and never made a power of attorney, or indeed perhaps never had the mental capacity to make such a decision in the first place. And when that happens, an application can be made to the Court of Protection for somebody to be appointed as their deputy. The first thing to observe is that because it's a big deal, obviously giving that kind of power, that kind of decision-making power to a third party, it's a more rigorous process to apply for deputyship, and the court will give a certain degree of scrutiny to these applications. And it's ultimately a decision that's made by a judge of the Court of Protection. And the Court of Protection is the court which was established by the Mental Capacity Act to make decisions around capacity and best interests on behalf of people who don't have capacity to make decisions for themselves. Many people listening to this will be familiar with the Mental Capacity Act, which is the law which sets decision-making processes, or how to make decisions on behalf of people who don't have capacity to make decisions for themselves. It sets out a definition of mental capacity and a process for making best interest decisions on behalf of people who don't have capacity to make those decisions. Crucially, The best interest decision-making process includes taking into account the views of those interested in the person's welfare, which generally will mean the person's friends and family. That's something a lot of people, particularly when they've got sons or daughters who are approaching the age of 18, or in some situations 16, and they've been used to the idea of being the decision maker for their son or daughter and being able to consent on their behalf to various decisions, and that they're suddenly being a very significant change in the legal framework when their son or daughter comes of age. People even talk about it in terms of it being a cliff edge when their son or daughter reaches that age. But that is what the Mental Capacity Act says, and that's how decisions are meant to be taken using the Act. The scope of the Mental Capacity Act is very wide-ranging. It really means that it covers any decision to be made on behalf of a person who can't make that decision for him or herself. And the general overall spirit of the Mental Capacity Act is that decisions should be taken informally, following that best interest decision-making process through a process of collaboration and consultation with the relevant people. But there is also a role for the Court of Protection in certain situations when serious decisions need to be made and consensus can't be reached through the best interest decision-making process. The Court of Protection can make a one-off decision on behalf of a person. So if there's a particular issue that needs to be decided, the court can make that decision on their behalf, or it can appoint a deputy for property and affairs or for health and welfare to make decisions on behalf of the person. Looking first at property and affairs deputyship, first thing to note is that far more deputies for property and affairs are appointed than deputies for welfare. For the last few years, the figure annually has been around 15,000 appointments of property and affairs deputies, as against only around 1,000 per year for personal welfare. The appointment of a property and affairs deputyship can be useful where somebody has assets over and above their income or monies accrued from welfare benefits. For example, if they own a property or a share of a property, or if they've got accrued savings from sources other than welfare benefits, or indeed if they've got savings or investments from prior employment or inheritance and so on. If a person is in a situation where their only income or capital is derived from state benefits, then in most cases an appointeeship will suffice. Though, as we'll be hearing from Jane later on, there are some situations where even there a property and affairs deputyship can be useful for dealing with tenancy agreements and similar arrangements. The process for applying to become a property and affairs deputy is meant to be something that someone could do without needing professional advisors, without needing solicitors or other lawyers involved. But having said that, the forms are not entirely straightforward, and many people do choose to pay lawyers to complete the forms on their behalf. There is guidance available on the government website for those choosing to go their own way, and many people do decide to complete the forms themselves, though you should be aware that there are various fees to pay as part of the application process. For example, there's a £365 application fee, and there are annual supervision fees involved, which range from £35 to £320. A property and affairs deputy has certain duties to keep good records of the transactions they've carried out in their role, and they have to they have to report back on an annual basis explaining what decisions they've made and how they've made those decisions during the course of the year. And people can find this to be quite onerous. And if we're looking at a situation where the person who lacks capacity has significant assets, it might be appropriate, and often is appropriate, for a professional such as a solicitor or an accountant to be invited to act as deputy. They will, of course, charge for their services, though, which obviously has an impact on the individual. Though it's also worth knowing that many local authorities have client finance departments who will be prepared to act as deputy, and in many cases they will do that without charge. So that's a very brief overview of property and affairs deputyship. Looking at welfare deputyship, first thing I'd say is that in an ideal world there would be little need for a welfare deputyship because, as I mentioned earlier, there is meant to be an ethos of collaborative and cooperative decision making around best interests for individuals. And when public authorities are properly consulting with friends and family members and involving them in those decisions, many friends and families might find that there's no need to be given the powers that come with a welfare deputyship. But back in the real world, many public authorities unfortunately still are not shall we say, fully compliant with the principles of the Mental Capacity Act and that need to consult. And many families find that by applying for welfare deputyship, they can seek to ensure that they are in fact consulted about the relevant decisions. But it's also important to understand that once somebody is appointed as deputy for welfare, they themselves also have to follow the best interest decision-making process under the Mental Capacity Act. And it may be the case that disputes will still arise, that agreement cannot be reached on what's in the person's best interest, and there would still be a need for decisions to be referred to the Court of Protection for a judge to make a decision in those circumstances. So what I always say to clients is that applying for welfare deputyship results in more of a shift of emphasis more than anything. The deputy becomes the decision maker for certain decisions rather than the public body. So many families, because of that, do find it helpful to have welfare deputyship. And it can also be particularly helpful in practical terms for things like medical appointments or dental appointments, where it can be really helpful on a day-to-day basis to have an official piece of paper with the court seal on it to say, I am the welfare deputy and I can consent on behalf of my son or daughter or other family member, or whoever it is. It's also important to understand that the Mental Capacity Act Code of Practice and some of the case law around welfare deputyship emphasises that it's preferable for the court to make one-off decisions on behalf of people rather than handing over the power of making decisions to an individual. It's quite a big deal to give someone that kind of power. And the Code of Practice says that welfare deputies will only be appointed in the most difficult of cases, though there was a case heard by Mr. Justice Hayden last year where he looked at these issues and he observed that wording of the Code of Practice may not in fact be correct, looking at the pure wording of the Act itself. And indeed, the Code of Practice is due to be reviewed and revised during the course of next year, so we will wait and see whether that particular phrase survives that review. So although the case law and the Code of Practice seems to say that welfare deputyships shouldn't generally be appointed, I should say that actually in practice the courts, the judges, seem to be very willing to appoint welfare deputies. I'm aware of a number of cases where they've gone through without question at all, really. So despite that case law and despite the recent trend, the judges are still willing to appoint welfare deputies, albeit more recently we're seeing they're making orders limiting the decision-making powers to very specific areas. So I think I'll leave it there and hand over to our next speaker, and that's my very brief whistle-stop tour of deputyship.
That's great. Thank you so much, Matthew. And like I said, there'll be questions. We will take questions after all the speakers have finished. So hi, Joe. Welcome, Joe. So Joe, you're in the thick of going through this process. Thank you so much for joining us.
Thanks, Julie. I am really in the thick of this. I'm waiting to get a decision from the court about the applications that I've made for deputyship, for both kinds of deputyship, for my younger of 2 sons. And yeah, it can feel quite daunting. So I did put it in the hands of a solicitor. So, you know, I have paid for someone else to fill in the forms and to know what to put where, and all I've had to do really is check it and sign it, which has been quite good for me, because there's so much other paperwork that you have to do when you've got a disabled offspring, son or daughter. So yeah, there was a lot of stuff going on when I needed to do this, and one of the reasons that I wanted to do this is because, as Matthew mentioned before, I'm in a situation where fairly soon my son will hopefully be moving out and going into independent living with a support team, and I will need to be able to sign a tenancy on his behalf, because he would not be able to understand that kind of paperwork. And I've got the support from the social worker that's a good thing for us to do, because then it gives us the control that he can't actually cope with over that kind of thing. And I've been his appointee for his benefits for years, and I was previously using direct payments on his behalf, so I I have been used to running his financial affairs for quite some time. He's now 21, so we're only doing this when it comes to the point where we need that legal additional power, if you like. And I've applied for the welfare deputyship, partly because I'm quite concerned, not just in general, but specifically around these times of COVID, that I can advocate for my son with a bit of clout behind his health needs, because I know him very well, and I do worry that there might be some kind of decisions made that wouldn't necessarily be the same as the ones that I might make for him in his best interests. And particularly in an emergency situation, because my son doesn't use words, so he can't explain his own illnesses or even point to where there might be some pain. And it's mainly through observation by people that know him well that we can ascertain what treatment might be useful. And I just worry that if I'm not consulted in those circumstances, then another decision might be taken or another assumption might be made about his health. So that's why I've gone for the deputyship for welfare, and I am waiting to hear still about that. I gather that the court was going to look at the decision next week. So yeah, we're just waiting to hear about that. But I think on the whole, the process has been very easy to have used a solicitor. I gather from a friend of mine who's recently gone through this process that you can also get support from people who are just independent advisors to support going through this process. They're not legally trained, but they've had lots of experience, and so that actually costs less than using a solicitor. So that's worth knowing. I didn't know about that until after I'd instructed a solicitor. So there we go. But yeah, a friend of mine has gone down that route. So it's someone who's used to doing these forms and knows the kind of thing that they need to know from the family member or whoever is applying for deputyship. So yeah, that's where I'm at, and fingers crossed I will get both, but it's fairly certain that I will get the property and affairs one according to my solicitor. It's just a question of waiting for the decision about the welfare one. So
great. Thank you, Joe. Thank you so much.
Thank you.
So next we've got Alan, and Alan and Anna are online. Hi, Alan.
Hi, Julie.
Thanks so much for joining us. So please tell us about how and what process you went through for Anna.
Okay, so I'm dad and main carer for Hannah. Hannah's now 32. She has a severe learning disability, autism and epilepsy. When she was 18, I went to her bank to withdraw some money, and I was refused, saying that I didn't have the authority to withdraw the money. So I had to start looking into and talking to lots of people about how I was going to be able to gain access to it. And a health professional told me that I would have to go down the Office of Public Guardian and Court of Protection route because Hannah lacked capacity, and that she would do the paperwork and sign a letter to say that she lacked capacity if I could do the paperwork for the application. So I phoned the Court of Protection up. They were very, very helpful, very friendly and helpful, and told me all the forms and sent what I needed. And they said that if I was stuck with anything, to give them a call and they would help me do that, which was very good of them. So we set a circle of friends up to involve on the best interest decisions side, so that you can use them and prove that you are making a best interest decision. And it was set up. So I got the court certificates, sent one into the bank, and I had access to the bank straight away. I took one into the doctors, so the doctors know whenever I call that that I'm allowed to speak on Hannah's behalf. And yeah, it's worked. It's worked very well. We did have to pay a one-off insurance bond that would pay out if anything went wrong, or if, like they would say, if her money disappeared. Yeah, it's great. So on the reporting, it's now all online, and you can dip into it and out of it and save what you've done. So the next time you don't have to do a year's report all at once. When you make a decision or you do something, you can go online, put it in the report, save it, and then it's there to send at the end of the year when they ask you for the report. The only downsides really is costs. The supervision fee for us is £320 a year. They do a 50% fee remission, but unfortunately the remission level is set below the benefits level. So if you get in ESA and PIP, you earn too much to get remission. But the fee is a disability-related expense against any direct payments from your local authority. Okay.
That's great. Thanks, Alan. Yeah, and I just think I find that really interesting that you've used it as a disability-related expenditure. So if anybody pays for care charges in that way, then potentially it wouldn't go off your minimum income. You'd be able to use that as a disability-related expenditure. I'm sure there'll be more questions on that later. Thank you so much, Alan.
Okay.
So our final speaker is Jane. Welcome back, Jane. So you'll remember Jane from last week as well for the power of attorney, and Jane's just going to talk us through some of the differences it makes having court of protection. Thanks, Jane.
Hi everybody. Yes, thank you for listening last week. And yes, the court of protection is a sort of one step upwards, basically. So for people who do not have capacity and people who are deemed to not have capacity, then we're actually looking at a deputyship potentially for property and finance and for welfare decisions. Over the years, I've found that increasingly that deputyships are important. In the past, there used to be more, I think, of people generally looking in a much more person-centred way. As Alan just spoke about, circles of support around people, moving into the direction very much of individualised, bespoke, supported living. And very, very often, because I've worked as a supported housing landlord for many, many years, we never felt it completely necessary to actually have a deputyship to sign the tenancy agreements. But as time has gone on, a tenancy agreement, like anything else, is a contract. It's actually a legal agreement between people. And as times have gone on and supported living has changed hugely over the years, the need to have somebody that is acting very much in place of that person as the tenant has become increasingly important. I'm sure there will be questions about that, but I'm asked very regularly where people, for example, because I support a lot of people coming out of hospital with complex support needs into their own homes, or people moving from home into their own homes, called supported living. And the The tenancy agreements have sometimes been signed by the care provider, which actually means the care provider can live there. Not the person, it's actually that contract is with the individual. It can be signed by a support worker sometimes, by a family member who hasn't got deputyship, and it's not worth anything. If there is ever a dispute with that, it's what is known as a voidable agreement, an agreement that doesn't exist. It's voided because the person didn't have the capacity and the other person didn't have the authority to make that contract. So it can be very, very problematic. And I've seen, as I say, increasingly where care providers become the people who start saying, well, somebody needs to move from where they are, or move bedrooms, for example, or they take over an area of somebody's property and put a lock on that and say that's our office, say that people can't visit, which has been more and more noticeable during the COVID-19 restrictions. And unless you've got that deputyship, it can be very, very hard to start representing that individual in a more official way. Thank you very much.
Thanks so much, Jane. Okay, so I've started to see that there's questions coming through the box now. If you want to start raising your hands as well to ask questions live, but I'll go through some that people have already asked. So Matt, this one for you. This is from Debbie. Can a paid long-term carer become somebody's deputy?
Well, there are some examples of deputies asking the court to authorise themselves being paid as carers from the person's estate, from the person's own monies. The court, as you'd expect, does scrutinise those requests very carefully. But there are examples of the court having agreed that the deputy can be paid as a carer for the individual. So it is technically possible, but someone in that situation can expect a great deal of scrutiny from the court. The ones I have in mind are situations where the person's already been appointed as deputy and then is asking to be paid. I think if it's known from the outset that it's a paid carer, I would expect to be giving the court to be giving it all the more scrutiny.
Yeah, definitely. And then, Jane, you were mentioning about tenancy arrangements. So Kate said, what would be the deputy's responsibilities in supporting somebody to sign a tenancy?
Okay, so you can't actually sign a tenancy unless you've got formal deputyship. But there are arrangements, rather than people having to get full deputyship, that's something called a one-off decision. So a one-off short order. Always reminds me of something from McDonald's or something, a short order, but that you can actually go to the Court of Protection and ask on a one-off basis. Now, what does happen sometimes is, and quite often actually, is that the local authority apply for that. And quite often they'll say to people, oh, don't worry about that, we'll put that in, where we're putting in also at the same time if there's any deprivation of liberty applications. So that can be perhaps that somebody can't go out on their own, or always needs to have 24-hour staffing with them, different ways that people may be restricted. And also they'll put in for what they call the short order or one-off order for the tenancy at the time. Quite often as well, taking over the appointeeship, because by their corporate appointees, because that means that they can set up the property, set up the fuel accounts, and set up various aspects about that person's money. And that can be problematic later on if, for example, you feel that the bills are far too high and they're just being paid by the appointee, the deputy and the appointee, because they actually feel that they're the most important bills, and you're actually finding that your loved one perhaps isn't getting all the leisure facilities, the leisure outings that you expected them to. So there can be lots of sort of small problems that come up, but also larger ones that come up. A deputy for property and finance, so actually making that application, it's not just a one-off on the tenancy. You can actually make other decisions for that person in relation to opening a bank account, which often can be difficult. It is possible It can often be very difficult entering into various contracts for people, including all the fuel and utilities contracts that people might need, insurance contracts, all the various things in terms of property and finance. In relation to welfare, they are the much bigger decisions about people, but again, as Matthew has said, you know, they tend to be decisions that will be restricted to certain aspects of that person's welfare.
Right, thanks, Jane. So there's a question here, Joe, that you might be able to answer. Who can help to do this if I can't afford a lawyer? So I know you said you knew somebody that had got an independent advisor. So if you have any contact or any further information on that.
Yeah, I do have a family carer who is a friend of mine has the details of someone who is I don't know if they call themselves an independent advisor for deputyship, and they don't charge as much as a legally qualified solicitor would do, but they basically go through, hold your hand through the process and just make sure that everything, you know, all the I's are dotted and the T's are crossed and you've signed in the right places, etc. And we'll check it for sense as well, what you've put in the forms, or we'll help you to decide what to put in the forms, give you advice on that. So they're not legally qualified though, obviously, so you know you've got to make a decision yourself about that. But yeah, I do have at least one contact, and I believe that this is not an uncommon thing. So
Brilliant, thanks, Joe. Thank you. Matt, another question for you, a question for Matt from Jane. Are the courts less likely to approve a PWD? Is this dependent upon the young person's needs?
Well, I mean, the stats show that fewer personal welfare deputies are appointed, though that might not necessarily be tell you what these stats are as against how many people are asking. It might just be that fewer people are asking. I think, though, it is fair to say the courts will ask themselves, why is this necessary? Why? What kinds of decision is the person wanted to make on behalf of the person they're applying in relation to? So what we've been doing, particularly since the case I mentioned that was heard by Mr. Justice Hayden last year, is we've been very specific in our applications when we're applying on behalf of people, on behalf of clients, why it's necessary. What are the particular circumstances of the person's situation? Are there previous examples where they've encountered difficulties with the best interest decision-making process, or public authorities, whether that's social services or healthcare bodies, not compliant with Mental Capacity Act Code of Practice, or perhaps simply decisions just need to be taken very quickly and very rapidly in quick succession, and explaining essentially that the crucial question being why it's in the person's best interests to have a welfare deputy. And we do that, we explain all that in an accompanying witness statement, the COP24 form for those looking at these things on the government website, setting out really it's the background to the matter, why the person, why the applicant thinks that a welfare deputy is required, and why it's in their best interests. So although as I say, the judges do seem to be willing to appoint welfare deputies, I do think it's going to be helpful to set out that background detail and explain why it's considered to be in the person's best interests.
Great, thanks, Matt. So Alan, I'm coming back to you. There's a question about, am I right in thinking, this is again from Jane, am I right in thinking there's no financial support for those that want to do this? And is it a massively expensive thing to do and difficult to do without solicitors' advice or without the money available to do that?
Well, I didn't think it was difficult to do without the legal side, because there's no money available for it, and you're always thinking of the best interests of your child. You either pay for it yourself or you charge your child out of their savings to do it. So that was the basis of me doing it myself, to save solicitors' fees, either from myself or from Hannah.
Yeah, and you were saying about people doing it for DRE. Is there any other? Because I know with power of attorney, I think you can get 50% off, but you're saying that actually that bar doesn't reach people who are on benefits anyway.
I think we're 12 years in now, and I think when it first started, I think we did get 50% remission, but they changed the level of the threshold, and it's actually about £50 above the level of benefits that you would normally get. So yeah, it's not there, but if I didn't pay that fee to the Court of Protection, we'd be paying that over the year under the fairer charges policy of the local authority for the direct payment. So it balances out.
Yeah, brilliant. Thanks, Alan. Jane, back to you. There's one saying that this is from Josephine, but there's also a number of other questions that sort of go in the same vein from Julie and Helen as well. And it's basically, without having this deputyship for welfare, is there anything you can do when you're excluded from decision making as a carer?
Well, if you're excluded from decision making, then we've lots of reasons why you are excluded, and sometimes that's purely because the the care provider has taken over that care and actually thinks that's what it's all about, actually taking over. Or there may be more reasons in that you haven't had a particularly good relationship with the local authority, so they haven't included you in any care planning or visiting when you're visiting the schemes, that people are asking you not to come at particular times, those sort of things. So first of all, if you're actually excluded, first of all, let's look to make sure that the person actually wants you to come. And that can be really difficult because a lot of families say to me, well, now my child's over 18 and they're in supported living, people are actually saying to me they don't want me to come any longer. Whilst they may understand that that's because somebody's doing some really great things, going out and having a really great time, and why would you want your mum or your dad to come at that point? They're actually feeling that sometimes people aren't having such a great time, and it's more that a care provider might be saying to someone, that they don't want to meet their parents. So the first stages of that is actually to bring that up with a care manager, the person that's commissioned the service, and if you don't get any joy from that, it's the usual complaints procedure. As a deputy for somebody, so as a deputy for property and finance, you're not just an appointed person to look after that person's finances, you're an agent for that person's decisions. So even a deputy for personal welfare can't decide who somebody sees or not. That has to be a best interest decision. So if you're being excluded from that, you would be requiring to have a best interest meeting about the matters that you're excluded from. The more position you have in that, so obviously the more of a position you've got as a deputy for personal welfare or a deputy for property and finance, you've got more clout in that best interest meeting. It doesn't mean that all the decisions are down to you, but you certainly, they will necessarily have to invite you to that meeting.
Brilliant, thanks, Jane.
Just go on as we have for the last 2 or 3 years without it. And have no problem. If it came to a difficult scenario, can you get it quickly, like an urgent one, or is there still a process of several months?
It does take several months. If there was a one-off decision that needed to be made, you can ultimately apply to the Court of Protection for a one-off decision, but that in itself is also quite a cumbersome process. It's really hard to predict what the future will bring. You might go through the rest of life without ever
Yeah.
encountering an issue like that, but as we've been hearing, there are, these things do come up, and probably Jane's a better guide as to how likely those scenarios are, because I say, by definition, I only ever see the problem cases, and I think Jane probably has a bit more wider experience than I do of what's actually happening on the ground.
Okay, thank you.
I think in a situation of COVID, you've got to really think these things, because there were a lot of there were decisions coming out from the government that people wouldn't even be put forward for treatment at one point, and DNRs were going on to all sorts of different people's files. I realise you've got a lot of control over that, but COVID, has actually brought in a very, very different scenario for people. So I think, it's just about thinking about that very carefully for your own family and own circumstances. But I said at the LPA meeting last week, I was actually I got over to a hospital for someone, and I know this was a couple of years ago, but they put the person who had Down syndrome on what they call the Liverpool pathway, and that actually meant he was going to be, allowed to sort of die gradually. They don't use that system any longer, but that's what was happening. No food and no liquids at that time. And by the intervention to get a peg put in, we had to have an LPA, a lasting power of attorney, to do that. And he, went on to have some really lovely years after that. So I do feel quite passionately, obviously, about people really considering that for their own circumstances.
Okay, thank you.
So I think people think we've come to past 11 o'clock now. So I'm very aware that there's some questions that have not been answered. We will take those questions away, and we will answer them questions and put them up on our website with the recording of this video. If you want anything individual that you don't want to do publicly on that question or go out publicly, there's 2 email addresses down there. There's the In Control email and the Be Human, so we'll try and answer that way. Finally, just thank you so much to our panel members, to Matt, to Joe, to Alan and Jane. Thank you so much for sharing your experience. Thanks everybody for coming and asking some really good questions. So just final comments from any of the panel?
Thank you for having me.
Yes, thank you. And like I say, the letter of the law is quite strict on these deputyship applications, but I know that the reality out there, the practical reality is somewhat different. And I think, as Jane was saying, I'd encourage people to think hard and maybe something that's appropriate for them.
Thanks, Matt.
Thank you, everyone.
Yeah.
I hope it's been useful.
Thanks, Alan. Joe?
Yeah, can I just say thanks for actually running these webinars, because I know that some of the people that I know will be, that there were so many questions at our families meeting just yesterday, and that Katie mentioned, so this is really valuable. Thanks to everybody who acts as a very helpful professional. Thank you, Matthew, because your advice is very valuable to people.
You're welcome.
It is. Thank you very much. And if there is any topics that you want us to do in this way, please again get in touch with us, and we'll definitely we'll do more on different topics. Thanks ever so much for coming, everybody. Take care. Bye.
Thank you. Bye-bye.
Bye.